Hello, I'm Alan Baker. I work as a family dispute resolution practitioner for Catholic Care, and I also do internal legal work for them. I'm talking today about aspects of the law relating to family counsellors. For those wanting chapter and verse, much of what I will speak about is contained in sections 10 B to 10 E of the Family Law Act, as well as in section 67 ZA relating to mandatory reporting. Who are family counsellors? The Attorney General's Department has a list of 81 organisations Australia-wide who are authorised to appoint people to be family counsellors. If you are not working for and authorised by one of those 81 organisations, you are not a family counsellor in the Family Law Act sense of that term. What is family counselling? There are three parts to the definition. 1, counselling about marriage issues. 2, counselling of people who are affected or are likely to be affected by separation issues. This includes both adults and children. And 3, counselling of people who are not the parents but have a significant enough interest in the well-being of a child as to be able to apply for court orders about the child. Grandparents or step-parents may be examples. This counselling must be about issues relating to the care of a child. There are a number of musts, must-nots and mays for family counsellors. These impact on the provision of compulsory information to clients, admissibility of evidence to a court, confidentiality and its exceptions, and mandatory reporting. We'll touch on some of these. Admissibility. The Act says that evidence about the content of family counselling is not admissible in any court, state or federal. This covers both your file and your verbal evidence. The exception to this rule is evidence about child abuse. That is admissible, and we'll come back to that shortly. The 2014 Queensland Supreme Court decision of Baden Clay has an interesting take on the term any court. It said that this term must be interpreted in the context of the Family Law Act definition of court, which means a court doing family law work. In that case, a family counsellor was required to give evidence in a high-profile murder trial. This decision has seemingly had minimal attention in other courts since then, and may or may not be applied in Victoria in the future. Child abuse. There is a lot of law and a lot of learning about what constitutes child abuse, both in the Act and elsewhere. Family counsellors need to be across this because it directly impacts on some of their obligations. The definition in the Act has 4 parts to it. First, an assault. Second, involving a child in sexual activity where there is an unequal power relationship. Third, causing a child to suffer serious psychological harm, including as a result of family violence. And note that the definition of family violence is wide. Number 4, serious neglect. If it is a child abuse situation, there are 2 significant implications. First, evidence of a family counsellor is admissible in court. Secondly, if it is a child abuse situation, family counsellors are mandated reporters pursuant to section 67 ZA. They are not mandated pursuant to the Children, Youth and Families Act, but they are mandated by the Family Law Act. DHHS, who are now DFFH, which is the Department of Families, Fairness and Housing, unfortunately sometimes overlooks this important fact and leaves family counsellors off some of the lists they provide of mandated reporters. Do not be confused by such omissions. If you are a family counsellor, you are a mandated reporter of child abuse. Finally, some other may disclose exceptions to the usual confidentiality rule. I'll mention 3. Number 1, a family counsellor may disclose otherwise confidential information in order to protect a child from the risk of harm. Number 2, a family counsellor may disclose otherwise confidential information for the purpose of reporting or preventing acts or threats of violence or property damage. Number 3, and importantly, a family counsellor may provide information to an independent children's lawyer if they believe that doing so would assist the ICL in their job of representing a child's interests. Be aware that in such may disclose situations, the Act says that unless it is a child abuse situation, the evidence of a family counsellor is not admissible in court. This can sometimes cause frustration for both the family counsellor and others, such as an ICL, but the words in the Act are clear on this point and are actually stated twice in order that there be no misunderstanding. So, family counsellors, make sure that you are aware of the musts, the must-nots and the mays of being a family counsellor.
Make sure to watch our other educational videos on various family law topics, available to watch on our website at www.vicflpn.org.au.